Hello, everyone. Welcome to the U.S. Immigration News. Can Immigration and Customs Enforcement, IC, detain you if you have a green card, officially known as a permanent resident card? In other words, will you be targeted by immigration enforcement if you have a green card? With President Donald Trump back in office, his administration has swiftly enacted executive orders that significantly impact immigration enforcement, even for green card holders. These directives have expanded expedited removal processes and increased the hiring of Immigration and Customs Enforcement, ICE agents, intensifying the scrutiny on all immigrants, including lawful permanent residents. A U.S. green card, also known as a permanent resident card, grants individuals the legal right to live, work, and travel in and out of the United States. However, despite this status, certain situations may lead to immigration authorities questioning a green card holder's residency or, in some cases, detaining and even initiating removal proceedings. The reality is more complicated. From extended travel to legal missteps, there are hidden pitfalls that could put your residency in jeopardy. In this video, we'll review how ICE targets green card holders and what to do and what not to do in such situations. If you are interested in this topic, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it, so that you may get updates straight to your smartphone. Now let's get into the video and get started. While green card holders generally have strong legal protections, they are not entirely immune from immigration enforcement. There are specific scenarios where permanent residents can be questioned, detained, or even placed in removal proceedings. The most common reasons include: Number 1. Extended time. Spent outside the USA green card is meant for individuals who intend to make the United States their primary residence. Some permanent residents, particularly elderly parents of U.S. citizens, may use their green card primarily as a means of easy entry into the country rather than as a commitment to live permanently in the U.S. The risk arises when a green card holder spends extensive time outside the country, especially if they remain abroad for over a year. This can create a presumption that they have abandoned their residency. If an individual returns after a long absence, they may be subjected to secondary inspection at the airport, where immigration officers will assess their intent to reside in the U.S. If they determine that residency has been abandoned, the case could be referred to an immigration judge. Some individuals find themselves unable to return due to unforeseen circumstances, such as serious medical conditions. While exceptions can be made in such cases, the burden is on the green card holder to prove that their absence was beyond their control. If questioned, it is highly advisable to consult an immigration attorney before making any formal statements or signing documents at the border. Number 2. Voluntary abandonment of residency, Form I-407. Immigration officers at airports may present individuals with Form I-407, a document that allows green card holders to voluntarily relinquish their residency status. Officers may suggest that signing the form will make it easier to reapply for a green card later, but this is not necessarily true. Signing this form can have serious consequences, as it effectively means giving up one's permanent resident status. If asked to sign Form I-407, do not sign it immediately. Instead, request legal representation before making any decisions. It is your right to have your case reviewed by an immigration judge rather than voluntarily giving up your status. Number 3. Criminal charges and immigration consequences. Permanent residents can still face removal from the US if they are convicted of certain crimes. Even minor offenses that may not seem serious can have significant immigration consequences. Many individuals assume that once they have completed the legal process for a criminal charge, such as having a record expunged or completing probation, they are in the clear. However, US immigration law treats criminal convictions differently than the regular criminal justice system. A conviction that may not seem severe under state law can still make a permanent resident subject to deportation under federal immigration laws. If a permanent resident is charged with a crime, they should consult both a criminal defense attorney and an immigration attorney to understand the potential impact on their immigration status. Some plea deals that seem favorable in criminal court can have devastating immigration consequences. Number 4. Failure to remove conditions on residency. Some permanent residents receive conditional green cards, which are typically valid for 2 years instead of 10. This is common for individuals who obtain residency through marriage to a US citizen. Before the 2-year expiration date, they must file Form I-751, a petition to remove conditions on their residency. Failure to do so on time can lead to the loss of their green card and potential placement in removal proceedings. This is important. Some green card holders mistakenly believe that they need to file a green card renewal, Form I-90, instead of the required I-751. Filing the wrong form can lead to delays or even termination of residency. If a conditional resident fails to file the I-751, or if their application is denied, they could be placed in deportation proceedings. Number 5. Failure to maintain residency requirements. Green card holders must ensure that they maintain strong ties to the US. This includes filing tax returns as a resident, maintaining a US address, and avoiding actions that suggest they do not intend to reside permanently in the US. If an immigration officer suspects that a permanent resident has primarily been living outside of the US without a valid reason, they may initiate an inquiry into whether the person has abandoned their status. Now, the next question: what happens if you are placed in removal proceedings? If a permanent resident is accused of violating immigration laws, they will typically receive a notice to appear, NTA, in immigration court. This begins the legal process of determining whether the individual can retain their green card or whether they will be ordered removed from the US. The legal process can take years to resolve, and during this time, the individual may remain in the US unless detained for specific reasons. In most cases, permanent residents who have no serious criminal record and have maintained their residency appropriately will not be detained. However, those with certain criminal convictions may be taken into custody by immigration authorities while their case is pending. In the end, let's look at how to protect your permanent resident status. To ensure that you maintain your green card and avoid unnecessary complications with immigration authorities, it is crucial to follow these key guidelines. 1. Be mindful of extended absences. Try not to stay outside the United States for more than 6 months in a single trip. If you anticipate needing to be abroad for an extended period, you may want to apply for a re-entry permit, Form I-131, which helps protect your status while you are away. 2. File taxes as a U.S. resident. Always file your tax returns as a U.S. resident. Filing as a non-resident can be seen as an indication that you do not consider the United States your permanent home, which could put your green card status at risk. 3. Stay clear of legal trouble. Any criminal charges, even minor ones, can have serious immigration consequences. If you are arrested or charged with a crime, it is essential to consult an immigration attorney before agreeing to any plea deals or settlements, as certain convictions can lead to deportation. 4. Don't sign Form I-407 without legal advice. If immigration authorities ask you to sign Form I-407, which voluntarily gives up your green card, do not do so without first speaking with an immigration attorney. Some officers may encourage you to sign it, claiming it will make things easier, but this can have long-term consequences. 5. Meet deadlines for removing conditions on your green card. If you have a conditional green card, usually obtained through marriage, make sure you file Form I-751 within the 90-day window before your card expires. Failing to do so can lead to loss of status and potential deportation proceedings. In general, green card holders who follow the rules and maintain their residency status have little to worry about. However, extended absences, criminal charges, or procedural mistakes can put a permanent resident at risk. Understanding your rights and obligations can help ensure that you continue to enjoy the benefits of permanent residency in the United States. For those seeking legal assistance, it is always advisable to consult with an experienced immigration attorney before taking any action that could impact your status. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.